that we need to be even more vigilant and attentive to sexual abuse that's happening in our system to those kids that are in our care. And as if it is the case with this reporting, as with most sexual abuse reporting, it's undoubtedly underreported. And so there's undoubtedly even more abuse going on that we need to prevent. And I'm so thankful to the Executive Board for their attention to this matter and their willingness to advance the bill and to grant it a priority. And I'm grateful also again to our Inspector General of Nebraska Child Welfare for her hard work and the hard work of her office to pull this report together. And again, I encourage you to check the reports tab on our website and see the reports of the Inspector General to see what this what is in the report and what needs and to see the other reports that she has done and how we're tracking what's happening and what we need to continue to work on. Again, this bill comes out of one of the rejected recommendations, and I also echo Senator Wishart in thanking Director Wallen and the department for the 11 recommendations that they did accept and that they're working forward on, and I'm grateful they did not oppose this bill to move forward on this recommendation as well. And colleagues, I appreciate the work of several other colleagues on this floor who have also read that report thoroughly and are looking at other possibilities to advance and continue to improve our child welfare system and make sure we're keeping these kids in our child welfare system and our juvenile justice system safe. And I urge your green vote on LB 1078. Thank you, Mr. President.
Thank you, Senator Crawford. You heard the closing on LB 1078. The question before us is advancement of LB 1078 to in our initial. All those in favor, please vote aye. All those opposed, vote nay. Have all voted that wish to? Please record.
37 ayes, no nays, Mr. President, on the advancement of LB 1078.
LB 1078 is advanced to in our initial. Mr. Clerk, for items.
Mr. President, thank you. Health and Human Services Committee chaired by Senator Repeat reports LB 1040 to general file with amendments. And I have a new A bill, LB 439A by Senator Wishart. It's a bill for NAC to appropriate funds to implement the provisions of LB 439. That's all that I have, Mr. President.
Next item, Mr. Clerk. Next bill, please.
Excuse me, Mr. President. Thank you. Legislative Bill 158, Mr. President, is a bill introduced by Senator Pansy Brooks. It's a bill for NAC relating to juveniles. It changes provisions relating to appointment of counsel for juveniles as standards for guardians ad litem and attorneys in juvenile court. The bill was introduced on January 9 of last year. At that time, it was referred to the Judiciary Committee. The bill was reported to general file, and there are committee amendments pending, Mr. President.
Thank you, Mr. Clerk. Senator Pansy Brooks, you're welcome to open on LB 158.
Thank you, Mr. President. Well, good morning, colleagues. I'm really happy to be back presenting this bill. I want to thank the 34 of you who have agreed to cloture if we really need to go that far. I want to start just reminding you a little bit. We have discussed right to counsel quite a bit for juveniles, and there have been some comments that, oh, well, it was already given to Lancaster Douglas and Sarpy, and that I wasn't going to bring it back. I never said that. I said that I might have said that I would not bring it back without a funding mechanism. So here I am for you with a funding mechanism. So I wanted to start and say that there are two things that I learned from my constitutional law professor. Number one, I learned, and this is good advice for all of us, don't be in the wrong place at the wrong time. Clearly, it's pretty difficult to determine which is the wrong place and which is the wrong time. But I would like to say that children are specifically predisposed to be in the wrong place at the wrong time. And but for the grace of God, many of us would be not here today and because we would have found ourselves in the wrong place at the wrong time. The second thing that I learned from my constitutional law professor was that the lawyer who represents himself has a fool as a client. I've taken that adage to heart. The lawyer who represents himself has a fool for a client, and how much more so a child. We're expecting a child to wander the abyss of the juvenile justice system, understand procedural matters, strategic matters, legal matters, all on their own. Well, they can have the judge or the county attorney wearing two hats, which is not constitutionally legal. But again, a child who represents himself has a fool for a client. But unfortunately, they generally aren't learned enough to know that. So I've sent out 5 handouts to you. Senator Moorfield said I'm killing a lot of trees today, but I want you to see two letters by judges showing that the counties have saved money by right to counsel. And part of it is they don't have to have the child in front of them and say, do you want counsel? And the child says, yes, I want counsel. Then everyone has to leave and they have to have another hearing. That's avoided. 2 hearings is avoided. I also have included the report on access to counsel that was paid for by our legislature in 2009 that says excessive waiver of counsel is our single largest issue in our juvenile justice system. And I also have handouts from Voices for Children and a letter. You can see we have justice by geography on a constitutional right. A constitutional right. The 6th Amendment allows the right to counsel if there's any chance that someone will be taken out of their home or put into detention. Because of the specific nature of the juvenile justice system, juvenile courts have specific powers where they can put somebody, a child, into detention for any crime. Now, we've heard all the arguments, oh, what about MIP? That wouldn't really happen. Well, guess what? It has. A child's been charged with MIP. They then run away from home. They then skip school for a week. So the judge determines they're out of control and puts them into detention with no counsel. That would not happen in adult court, my friends. So I have worked, meanwhile, with NACO on a funding mechanism. We have Amendment 1809 that's coming up. I hope you'll pass it. You all received a letter from NACO that said with an amendment that's a funding mechanism that they would support this bill. It's a funding mechanism that adds $1 to court costs. We have the single lowest court costs in the country thanks to Senator Chambers. So we have never had, we have an adult indigent defense fund. We do not have a juvenile indigent defense fund. So further, we have put into the bill that parents will pay for it if they can. So we've made sure that the counties are covered. I hope Senator Halloran will stand up at some point and talk about the fact that they had a case in their county where they were required to provide counsel, and it cost $30,000 to that county. Well, that's exactly something I'm trying to avoid and to help save dollars for the counties, because that county could apply to this juvenile defense fund and get reimbursement for that cost. So this is a mechanism that will not only help children have their constitutional rights, but also be able to make sure that counties can get their costs covered. These issues are real consequences for kids. I would say to you, my friends, that if the county attorney believes that the case is serious enough to warrant being in juvenile court where anything, including detention, can happen to the child, then it's serious enough for a child to have a lawyer. Otherwise, the child could just be sent to diversion by the county attorney, and there's no need for a case to go to court and no need for an attorney. Let me repeat that. I heard from somebody on the floor today saying, oh, well, they even need to have a lawyer for diversion. No, under statutes, they do not need to do so. They can send the child to diversion and no attorney is necessary. So there's all sorts of mistruths and untruths and incorrect statements being bantied about here. Judges, prosecutors, defense attorneys. There are three parties in our system. All serve different and distinct purposes. All are central to our justice system. Is it easier not to have a defense counsel? You bet. I know why the county attorneys may be complaining at times. I hope that each of you who has talked to a county attorney has also talked to a public defender. It's a lot easier for the prosecutors if there's not an attorney on the other side. This is the right thing to do. I have heard you. I've provided the funding mechanism. The counties do not have an argument against it. And I have the court administrator system in the lobby and Larry Dix with NACO. If you have a question, go talk to them. They have all pulled their objection. And so I ask